Chapter 6 Intellectual Property Law. Intellectual property is an interesting and sometimes contentious area of law. The concept behind intellectual property is not new, nor is the controversy about its existence. We talked in Chapter 1 about Article 1, Section 8 of the Constitution. It is the list of areas where Congress is permitted to create law. Clause 8 addresses intellectual property, granting Congress the power to make laws, quote, to promote the progress of science and useful arts, by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Like many areas of the Constitution, the opening line explains the intent, and the following line explains the actual specifics. The goal of intellectual property is to promote the progress of science and the useful arts. How does intellectual property do this? By securing to authors and inventors the exclusive right to their respective writings and discoveries, we are incentivizing people putting the time, resources, and effort into that work. A pharmaceutical company is less likely to spend millions on research and development of a new drug if the minute they do so, another company is able to come in and make a generic version. An author or a painter is going to be less able to make their living in art or writing if others can simply steal their work once it's done. But the main problem with intellectual property is that by giving their author or inventor exclusive rights to their work, we are shutting their discovery out from the world for others to prove upon or to provide to a society that might need it. This is why Ben Franklin didn't patent the lightning rod once he invented it. He wanted one on every possible building, and by not patenting it, saved many lives. More recently, Elon Musk, CEO of Tesla Motors, released the patents on some batteries so others could perhaps improve upon the design. Most people don't put their products into the public domain, so intellectual property is only protected for limited times to ensure that there is an eventual expiration date, allowing the benefits of these works and inventions to flow to everyone instead of just those the author or inventor deems worthy. Another major criticism of intellectual property rights is that they can be bought or sold. This can cause some conflict when an author or inventor sells their right to a third party who markets it for a larger profit. In this case, it is not the actual author or inventor with the property right, though they do profit from its sale. The main forms of intellectual property we are going to cover are copyrights, trademarks, patents, and trade secrets. Each has unique attributes and limits on their protection. Some forms of intellectual property may be covered by more than one form of intellectual property right, such as the unique shape of the Coca-Cola bottle and label, which would be protected by trademark, the characters in their commercials protected by copyright, and finally the recipe itself, which may be protected by patents or trade secrets. We'll discuss what each one is, how to get one, and what happens in the event of infringement. Copyrights. A copyright is a type of intellectual property protection that covers original creative works of authorship. This would include things like books, paintings, photographs, movies, video games, architectural drawings, clothing designs, or songs, among countless other things, so long as they are creative works. Some items, like software, may be protected by patent as well as copyright. Copyrights provide protection to the author for 70 years after their death. So not only the author profits, but so too can his children, grandchildren, and estate as his will or trust lays out. Alternatively, if it is a work for hire, the copyright protection is owned by the business for 120 years after its creation. As I write this book, the protection on it will last 70 years after I die. However, if the university required me to write this book as part of my job, then the copyright would belong to the university, not to me, and it would last 120 years. A copyright only covers the fixed expression of an idea. An idea alone cannot gain copyright protection. You must remove your brilliant idea from your brilliantly wrinkled little pink brain and turn it into something real before you can get a copyright. This means that you should be very cautious who you tell your brilliant ideas to. Should they steal your idea and put it to a fixed form, then you'd be infringing upon their copyright of your idea. How to get a copyright. Getting your work copyrighted is simple. If you create something able to be protected by copyright, it is. That's it. Just make it. You have a common law copyright protection from the minute the item is created. You don't need to ask the government for a copyright. You don't need to attach any notice on your work. You only need to make it, and the copyright protection automatically vests. Once you create your work, you can, if you so choose, attach the Circle C symbol to your work. This is not required for your work to be protected by copyright. However, You may choose to do so regardless of whether or not you file with the U.S. Copyright Office. Some people put nothing on their work. Others put a watermark. Some put Circle C, and others put Circle C followed by the year the work was created. All of these share the same level of copyright protection. The reason you may decide to put Circle C on the work would be to put others on notice that the work is copyrighted and that you care enough to protect your work from those who would infringe upon it. Most people have no idea that a work is copyrighted without the Circle C. You're making sure that they know your work is copyrighted. You may also choose, in addition to attaching Circle C to your work, to register your copyright with the U.S. Copyright Office. This is a necessary step prior to suing someone for infringing upon your copyright, but it is not required for the copyright to exist. You can register after the infringement and then sue, but if it is something important that you intend to protect, then it is good practice to register your copyright first. By doing so, you remove any question about who owns the copyright, since the defendant cannot claim to have created the item before you because there will be a record on file. Copyright infringement. When you have the copyright on something, it is not just for the exact thing and format you applied for the copyright of. The copyright holder has the exclusive right to all forms of reproduction, performances, publications, and displays of that copyrighted material. When Spider-Man was copyrighted, it protected more than comic books. It protected Spider-Man cartoons, live musicals, movies, video games, posters, and more, not just comic books. There are a few different ways a defendant might infringe on a copyright. There is direct infringement, contributory infringement, and vicarious infringement. Remember, while you don't have to register a copyright to have the protection, you must register your copyright with the U.S. Copyright Office to sue someone for the infringement. Direct infringement is simple. You simply prove to the court that you had a copyright and the other person copied, performed, displayed, or made a derivative of your creation. Contributory infringement means that someone knowingly aided the direct infringer. In this case, the plaintiff is suing two defendants. Knowingly is the key word for contributory infringement. If they were under the impression that they were aiding someone else's original work, then they would not be liable for contributory infringement. Vicarious infringement is similar to the doctrine of respondeat superior, but applied to copyright law. If you recall, respondeat superior is the doctrine that holds a business responsible for the actions of their employees when operating within the scope of their employment. When suing for copyright infringement, you can recover the actual damages you've suffered or statutory damages. Actual damages are the amount you can actually prove that you've suffered due to the defendant's infringement. Perhaps someone infringed on your work and made $300,000 from it. Then you should sue at least for that amount. Perhaps someone made a derivative of your work that was terrible and caused people to stop being interested in your work, hurting future sales. These are all actual damages. Actual damages can sometimes be difficult to prove. Because of this, there are damage amounts set by statute. For each work of the plaintiff's that was infringed upon, she can recover between $750 to $30,000. But if you can prove that the defendant knew they infringed upon the work, the plaintiff can recover up to $150,000. This is another good reason to attach a Circle C or some other notice to your work. You now know that all creative works have a copyright even without a notice, but most people do not. By putting them on notice, they cannot claim ignorance, making for greater statutory damages when you decide to sue. It is imperative to notice that it does not matter whether someone makes a profit from their infringement for it to be actionable. Even an infringement with no profit motive whatsoever can be acted upon. The fair use exception to copyright. There are times when a person is allowed to infringe upon another's copyright. Under the fair use exception, the court takes a totality of the circumstances view of a copyright infringement to determine whether it is permissible by law. There are 4 factors the finder of fact, the jury or a judge in a bench trial, will consider when determining if an infringement is considered fair use. The smartest thing to do, even if you believe you will fall under fair use, is to first seek permission from the copyright owner. It is simply a good and respectful practice. It's also the safest thing to do because you might be certain you fall under fair use and end up very wrong. The 4 factors are the purpose and character of the infringement, the number of copies made, the nature of the original work, and the effect on the market. The purpose and character of the infringement. Not having a commercial purpose is not enough to single-handedly protect you from copyright infringement, but it certainly helps. If you're infringing on copyright, but doing so for educational purposes, That improves the chances that the infringement will fall under fair use. But again, this is a totality of the circumstances test, and no one factor is determinative by itself. Just because something is educational doesn't mean that there's no profit motive. But the less money you're making on the infringement, the better. There's also the matter of parody as opposed to satire. Parody is frequently considered fair use, but satire is not. You must be cautious though, because the difference between the two can be razor thin. Parody is making your own creation through imitation of another work, most often for comedic purposes. It might copy situations or writing, drawing styles to mock the original work. With satire, you're doing the same thing, but you're doing it for your own purposes and to make your own point. You aren't playing around with the original work, you're using it as a tool for your own stories, ideas, and themes. This is an incredibly thin line, and first seeking the copyright owner's permission is the safest practice because lawyers and judges alike come to different conclusions all the time as to what is parody and what is satire. The number of copies made. The fewer the number of copies made, the more likely it is that something will fall under fair use. Consider when a person draws a copyrighted character and shows it off to their friends or puts it on their YouTube channel. They aren't making many copies to distribute to the world. They're drawing something for their own personal enjoyment or to show off their talent as opposed to turning a profit from another's work. The nature of the original work. Nonfiction works are more likely to be considered fair use. If someone writes about a historical figure or takes a picture of a celebrity, it's difficult for them to argue that writing about another person or event somehow grants them the sole ability to do so. The manner they have done it might be original, and they may not produce copies of their pictures or books. But the fair use exception will allow others to write about that topic or take pictures of that celebrity or event. The effect on the market. The less effect an infringement has on the market, the more likely it is that it will be considered fair use. If you're causing no actual damage to the copyright holder, or in some cases even assisting them, that alone does not remove the copyright infringement. That's why there are statutory damages. But having a minute effect on the market does, when combined with the other factors, improve the odds that the fair use exception will be applied. The fair use exception in action. Sometimes in class, I will play video clips from popular movies to help illustrate legal points. I believe these clips fall under the fair use exception. However, I will never be certain that I'm correct until a copyright holder sues me and a finder of fact makes the determination on if the fair use exception will apply. An argument in court might look something like this. Under the purpose and character element, I would argue that I'm using these clips for an educational purpose, to illustrate legal principles to class. The plaintiff would argue that while that might be true, I'm an employee and getting paid, so there's a commercial aspect to it. I would retort that it is a state school, not a private, for-profit university. As to the number of copies made, I would show that I only show the clips once per semester, and sometimes only once ever. I would also point out the fact that I do not release my slides to the class, as that would involve several hundred copies being made each semester. For the nature of the original work, infringement would depend on if I'm using news footage, raw film, or clips from movies. If they're clips from fictional movies, then the plaintiff would have this factor in their favor. And finally, toward the effect on the market, I would point out that the copyright holder of many of these movies, especially older ones, are not only not injured, but perhaps even helped by my showing of these clips. An interesting movie clip might well motivate a student to go and watch that movie. None of the clips shown in class are long enough that a student who might have seen the movie will be dissuaded against it. For the above reasons, it is highly likely that the fair use exception will apply. But when a case goes to trial, you never really know what's going to happen. That is why the smartest course of action is to seek permission from the copyright holder or to use alternative dispute resolution that we covered in Chapter 2. Another thing that is very helpful in these sorts of scenarios is simply to give credit to the original copyright holder. Don't use someone else's copyright for something that they'd find offensive to their interest, to make money off another's labor, and don't try to take credit for someone else's work. Oftentimes, you'll find that people will be very reasonable if you're not a jerk. Trademarks. A trademark is a word, phrase, symbol, or design that helps differentiate one product from another. When you go to the grocery store and want to buy a soda, they don't just have a row of random lemon lime or cola all mixed together. You want a 7-Up or a Sprite. You want a Coca-Cola or a Pepsi. People opt to pick different brands for different products for all sorts of reasons. Maybe they associate a positive feeling with the brand. Maybe they believe one is superior to the other, the way all those nerds bicker about whether Ford or Chevy makes better trucks, when we all know Dodge does. Some brands are associated with a certain image people want to portray. Whatever the reason people have to prefer one thing over another, a trademark is a quick way to associate the brand with the product. There are 3 types of trademarks: logos, slogans, and trade dress. We will discuss each of these as well as the process to get a trademark. Logos are what we most commonly associate with trademarks. They're the designs you see on or around the product. They're the WSU Cougar, the Starbucks Siren, the Green Monster Energy M, the McDonald's Golden Arches, the Tesla T, and on and on and on. Slogans are the mottos, sayings, or catchphrases that are associated with a product. Red Bull gives you wings. Got milk? Just do it. Let's get ready to rumble. I'm loving it. And easy breezy beautiful cover girl are all examples of trademarked slogans. Lastly, we have trade dress. Trade dress is the all-around way a product is presented. It can encompass the placement of items, the font in which words are written, and certainly the specific colors in the presentation of the product. If you see John Deere green and yellow, or the Barbie neon pink, you know how unique a color can be. Consider the shape of certain bottles, or soda, or the wax top of Maker's Mark whiskey. Their uniqueness can be considered trade dress. How to create a trademark. Trademarks, like copyrights, come with common law protection the minute you make them. If you want to use your own logo, slogan, or trade dress as a trademark to identify the uniqueness of your product, you can do so without registering it with the U.S. Patent and Trademark Office. This is, of course, so long as you're not infringing upon someone else's trademark. If you want to identify your logo, slogan, or trade dress as your trademark, you can simply add TM. However, if you want to strengthen your trademark protection, you'll need to register it with the U.S. Patent and Trademark Office. The office will ensure that your logo, slogan, or trade dress comply with the Lanham Trademark Act. If it does, then your trademark will be officially registered, and instead of TM, you will use Circle R, denoting that it's a registered trademark. Registered trademarks last for 10 years. You can renew it every 5 years after that. So long as you're renewing your trademark and continuing to use it in commerce, your trademark protection can continue forever. The Lanham Trademark Act is the primary statute that establishes and regulates trademarks in the United States. One of the things the Act does is establishes the various classifications of trademarks. Some trademarks, such as arbitrary or fanciful ones, are very likely to be accepted for registration. Descriptive ones are unlikely to be accepted, and suggestive ones are somewhere in the middle, with some accepted and others not. Lastly, we have generic trademarks, which have lost their protection. Fanciful trademarks are completely and totally made up. A fanciful word would be a word that does not exist anywhere else. A fanciful logo will not look like anything else. The Adidas logo and name are completely made up. Arbitrary trademarks aren't connected to the product at all, but the word or picture might be familiar. A black cat has nothing to do with fireworks. Apples have nothing to do with computers. Suggestive trademarks don't exactly describe a product, but they pretty clearly allude to what the product is. The seafood company, Chicken of the Sea, is an example of a suggestive trademark. There are no chicken in the sea, but chicken is a common meat product, so you know it's talking about food coming out of the ocean without them saying it outright. PlayStation, I'm just looking around my house now as I come up with all of these, is an example of a suggestive trademark. It isn't specifically saying that it's a video game system, but you know involves a station for playing. Descriptive trademarks may, but are not often accepted for trademark registration. Fresh Clean Tees is a t-shirt company that makes, well, fresh and clean t-shirts. Some people seek to start with a TM on their descriptive trademark, and then, if over the course of several years the product becomes sufficiently unique, they will occasionally be able to get the trademark registered. Remember, the purpose of a trademark is to be able to differentiate between like goods and services. If your descriptive trademark has developed the following and is clearly able to identify your product and how it is different from like products, you might be able to get a descriptive trademark registered. A descriptive trademark simply describes the product. Last are generic trademarks. A generic trademark is one that was at one time unique but has since come so widespread that it has lost its uniqueness. Aspirin, escalator, trampoline, and flip phone are all terms that were at one point trademarked, but no longer have trademark protection. Today, they are used in a generic sense to describe all brands of that product. One should be very careful when dealing with generic trademarks because there are cases where the trademark registration still exists and has continued to be renewed despite the trademark being used in a general sense. Kleenex is often used to describe any sort of facial tissue. Coke is often used as a generic term for any soda. You can use these terms in their generic sense, but be cautious not to infringe upon their trademarks. So long as they are renewing their trademark, they can keep it, even when its meaning has become generic. Trademark infringement. Trademark infringement generally requires a higher level of intent than copyright infringement. If the point of a trademark is to protect a brand's uniqueness, then infringement is a little more difficult to allege than with copyright. With a copyright, you needn't demonstrate a commercial intent for copyright infringement to occur, but with trademarks you do. Proving trademark infringement requires 3 elements. You own the trademark was used in commerce, and most importantly, customers are likely to be confused by the source of the product. The best way to show that you own the trademark is to choose a trademark that you can register under the Lanham Act and then actually register it. This puts the world on notice that you own the trademark, and it removes any possible evidentiary battles over who had it first, a problem you can run into with the TM common law protection, since there's no official record of it on file anywhere. The trademark must be used for a commercial purpose. If the purpose of a trademark is to clearly demonstrate the uniqueness of the product, but customers realize that 2 different sources of the product are involved, then the uniqueness remains and there is no infringement. The main causes of trademark infringement are blurring and tarnishment. Trademark infringement can include both copying a trademark exactly or choosing something substantially similar to the original trademark. Trademark blurring. With trademark blurring, the defendant is confusing the uniqueness of the trademark owner's brand by either using the trademark on a different product or using their own unique trademark that is very close to the plaintiff's to piggyback off of their popularity in the hope that customers will assume the 2 products are related. In 2023, the Supreme Court found there to be a trademark infringement by a company that produced a dog toy labeled Bad Spaniels, the old number 2 on your Tennessee carpet. The toy copied Jack Daniel's unique trade dress by using the shape of their whiskey bottle and the special font unique to their products. The court found that this was likely to confuse customers as to the source of the product. Trademark tarnishment. Trademark tarnishment occurs when a trademark is used in a way that brings disrepute upon the trademark's owner. In the chapter on torts, we discussed false light, where you don't exactly defame someone, but you imply the negative or defamatory statement. Tarnishment is similar, but it's associating the product with the negative action or poor quality as opposed to an individual. Sometimes a television show or commercial might blur out logos or avoid using known trademarks. There are many reasons for this, but one is simply using an abundance of caution to avoid possible tarnishment lawsuits. It is acceptable to use someone's trademark in your show since you're not using it in commerce or attempting to confuse customers. But lawyers are a risk-averse people and often advise their clients to use more caution than is sometimes necessary. An example of trademark tarnishment arose in a case in 2000 when Mattel, the owners of the Barbie brand, sued and won against the adult website barbiesplaypen.com, causing the courts to order an injunction demanding that the site be taken down. Mattel's argument was that associating the Barbie brand with pornography would injure the brand's reputation and therefore hurt sales of the brand. Trademark fair use. As with copyright, there is a fair use exception for trademarks. Parodies, such as songs like those made by Weird Al Yankovic or Barbie Girl by Aqua, are acceptable fair use. However, you still need to be cautious to ensure that there is no likelihood to confuse the source of the product. Just as with the previously mentioned Bad Spaniels example, parody will not help you if your product might be confused as originating from or a license being given by the trademark owner. Product reviews and comparative ads are also acceptable uses. Remember, for trademark infringement to occur, there must be some confusion to the customer. Comparative ads and product reviews do not dilute the uniqueness of the brand, and the reviewer is not attempting to make a person think that they created the product. Using the other person's trademark is necessary to accurately identify the product and differentiate it from its competitors for the evaluation. Patents. A patent is an intellectual property right that grants the owner the right to be the exclusive creator or distributor of a product. Patents cover things as opposed to copyrights, which cover creative works. Patents most often apply to inventions, but they can also cover processes or methods of producing items. Software covers a sort of middle ground and can be either patented or copyrighted. A patent can also cover a new composition of matter, like a new chemical or drug. The patented product must be an original creation. A discovery is not patentable. There are two sorts of patents: utility patents and design patents. A utility patent is the actual product itself. It is what we most commonly think of when we think of a patent. A design patent, on the other hand, is the appearance or way the product is displayed. It's the way the product is designed to appear. The shape and design of a cell phone, game console, or furniture may be eligible for a design patent. How to get a patent. The process of getting a patent can be long, expensive, and difficult. You will need to file a patent application with the U.S. Patent and Trademark Office. Your application will include all of the details outlining your product, such as blueprints, CAD drawings, chemical schematics, or anything else you have. For this reason, a special kind of attorney is required. Not every attorney is allowed to practice patent law. For an attorney to be admitted to the patent bar, not only must that person be a practicing attorney, but they also must have several dozen college credits in engineering or the hard sciences. Because most people in these majors do not opt to go to law school, patent attorneys are often more expensive than normal attorneys. If the U.S. Patent and Trademark Office approves your patent application, you will be the only person able to create or sell the product. Utility patents last for 20 years, and design patents last for 15 years. Because of how long the patent process takes, many people seek a provisional patent application. This is a much simpler process, but it is less detailed and only provides protection for 1 year. Trade secrets. Trade secrets are a unique form of intellectual property. What makes them unique is that they have the full legal protections of other forms of intellectual property, to include criminal liability for those that disclose those trade secrets. However, the owner of the trade secret need not file their trade secret with any government entity or office. Trade secrets can last forever, or as long as you can keep the secret. Trade secrets are any sort of secret your business has that gives you a unique advantage over your competition. You need to weigh whether you want to protect your trade secret according to these rules, or if you want to protect your secret with a patent or other form of intellectual property. Most of the time, trade secrets are used to protect things like recipes. Coca-Cola is the most famous example of a trade secret, but chemicals such as WD-40, or pretty much anything else, may be protected by trade secrets. The primary reason a person would opt for trade secret protection over a patent is that a patent not only limits the time of the protection to a maximum of 20 years, but when that time is up, anyone can simply look at the records you provided to the U.S. Patent and Trademark Office and make the product themselves. This happens frequently with generic medications. The danger of opting for trade secret protections is that if a person invents it on their own, or somehow takes apart and back engineers the product themselves, they can make the product and your protection is completely lost. The bottom line on trade secret protections is that they are the better choice, but only so long as you're confident that you can in fact protect that secret. Companies protect trade secrets in several ways. They might keep employees on a need-to-know basis. Perhaps employees are only made aware of part of the product, but no one knows enough alone to make the product completely. Those employees should be made to sign non-disclosure agreements requiring them to take their secret to the graves. Secrets should be locked away so no one else can get their hands on them, and leaks of secrets must be enforced. If someone attempts to leak the secret, you must sue or report it to authorities to prevent its disclosure. Your protections exist only if you're able to keep and enforce your secret. Trade secrets are protected both by federal and state law. They are protected by both criminal and civil penalties. Infringement, called misappropriation of trade secrets, occurs when a person acquires the trade secret by theft or a violation of confidentiality agreements. Liability can also attach to a third party if they purchase or accept the trade secret from someone they know has stolen it, or if they induce a breach of confidentiality. In 2006, an officer of the Coca-Cola Corporation offered to sell the recipe of a new variety of soda to rival Pepsi-Cola. Pepsi reported the offer, and the officer was then sent to prison. Pepsi-Cola did not report this out of some sense of honor, but rather because, had they accepted it, they would have been held criminally liable along with the Coca-Cola officer. When you can use another's intellectual property. Intellectual property of any type is simply another form of property. It can be bought, sold, or rented the same way any other piece of property can. It's common for an inventor or creator to sell their intellectual property right to another, granting them the right to use it instead of the original creator. For example, in the film Wayne's World, Wayne Campbell, played by Mike Myers, sells the rights to his show to a larger company, Noah's Arcade. When Wayne quits the show, he's informed that if he makes the show on his own, that he'll be sued for copyright infringement, even though he was the creator of the show. Selling the intellectual property right to another is referred to as assigning the rights to another. Alternatively, the property right holder can retain their ownership right, but allow another person or entity to use it for a fee. This is referred to as allowing them to license the product. For example, when a clothing company such as Nike sells a jersey for an athlete, they must get a license from the sports team whose logo they are using. When a movie uses someone else's song in a film, they are licensing the song. The person who owns the license is called the licensor, and the person who has purchased the right to use, but not own the intellectual property right, is the licensee. The licensee pays royalties to the owner of the intellectual property right holder. A famous example of this is the well-known jingle, Think, that is aired during every episode of Jeopardy before the contestants answer the final clue. Merv Griffin, the creator, is paid royalties every single time it's played. It has netted him between $70 to $100 million to date. In most cases, the owner of intellectual property has the right to decide what to do with their right. An exception to this is called a mechanical license. A mechanical license gives someone the authority to make cover songs of someone else's copyrighted work or to sample a part of it and apply it to their own music. Mechanical licenses are granted by federal law and have royalty rates set by statute. The public domain. Work in the public domain is work that either never was protected by one of the above-mentioned intellectual property rights or one whose protection has expired. You are free to use things in the public domain in any way you want, and you needn't ask anyone's permission to use it. Some people create works and explicitly decide not to place a copyright or other intellectual property protection upon it. It is generally good practice to credit the original creator from an ethical perspective, but no such legal requirement exists. Remember that copyright protection attaches regardless of if a person explicitly claims it, so for a recent copyrighted work to be in the public domain, the creator must explicitly disclaim any protection. Another example of things in the public domain are things created by the U.S. federal government. This is not all things made by all forms of government. Every state and city have their own rules. Not all the intellectual property that the federal government owns is in the public domain. Only the property it creates. Even then, they may occasionally carve out exceptions for federal government products, as has been done in the past for characters like Smokey the Bear. Likewise, if the federal government were to purchase the property right from the original owner, then it is not in the public domain. For example, in the fiction book Atlas Shrugged by Ayn Rand, the government purchases Hank Rearden's patented Rearden metal so they can prevent it from being made. They did this to protect the steel industry. Lastly, and most commonly, works in the public domain are those whose protection time has lapsed. We've discussed the length of time copyrights, trademarks, and patents last. When that time expires, the property enters the public domain. Be cautious and make certain something you believe is in the public domain does not fall under some obscure exception. Disney, for example, is extremely protective of their intellectual property and has in the past successfully lobbied to change copyright laws and carve out exceptions. Disney has also reimagined characters to refresh copyrights on newer versions of them. For example, a recent Winnie the Pooh horror film was released involving the famous bear, but he was not able to wear his signature red shirt because only the shirtless version of him has entered the public domain. Oh, bother.